It's been a number of weeks since I've done a video blog here, and frankly, some of the written blogs have been a little bit light over the last couple weeks comparatively, and that's because I've been inundated and buried under a bunch of pretty deep work here, a good couple appeals that I've posted, and then some significant other postings and other work that has been quite overwhelming, frankly. Well, this morning I wanted to share something which is quite exciting and frankly pretty extraordinary, and it's right back there behind me there. You see that stack of papers and the box that it came in. This box is a big document box right there, and this right here is a big stack of papers. Now, why this is important is in the context of foreclosure cases, we're often sued by the XYZ 2006 trust or Deutsche Bank as trustee for the 2006 Alt-A trust plaintiff versus Matt Weidner defendant. And I think it is always relevant, no matter who the plaintiff is, that we have some inquiry and investigation into who that plaintiff is. Some of the first complaints that I ever filed, some of the first answers I filed to complaints are motions to dismiss, were motions that were directed at capacity. When I would read what I call that alphabet soup plaintiff, the XYZ 2006 trust, I would ask the court, I don't recognize this entity and I need more information about who this trust is so that I can formulate a better response. For instance, who do I serve if that case is dismissed and I need to go after them for something else? Or because I'm a title attorney, a question that I have is, if a title to a property is entered to one of these alphabet soup trusts, as a title attorney, I need to know who it is that I serve if I've got to clear out a judgment or some other interest in there. And, you know, unfortunately, too many people don't understand the fact that title is such an important part of this foreclosure process. In fact, it's the most important part of the foreclosure process, and people tend to ignore that. Judges who are used to typical civil litigation just look at plaintiff and defendant and don't understand that at the end of the day, being able to specifically identify who the parties are is an absolutely essential element of a foreclosure case. When we go 5, 10 years, and frankly, I've even had to go back 20 years after a foreclosure and try and identify who the plaintiff in those cases were and try and locate who those plaintiffs are so that I can clear out title. And what people don't seem to understand is if you just have one of these alphabet soup trusts without clearly and distinctly identifying who it is and how to serve them, our rules of civil procedure and our rules of title make it very difficult. And frankly, there's no way for us to clear that title out. It's just very simple. If it's a corporation, we need to specifically identify who that corporation is. I really remember one of the first answers that I ever filed was against a corporation known as Freedom Mortgage Corporation. I asked the court, they need to identify in what state is Freedom Mortgage Incorporated, because as I did a corporate search, I found at least 4 separate and distinct Freedom Mortgage Corporations. One was in New Jersey, and one was in Ohio, and one was a Florida corporation. And the point that I made was, when we have a plaintiff, Freedom Mortgage Corporation, suing Matt Weidner, and they have not identified Freedom Mortgage Corporation, the Omaha or the Utah corporation, then we don't know which corporation is suing. And that comes as a result of my years of title experience as a title attorney. So if we've got a judgment in favor of a plaintiff that's Freedom Mortgage Corporation, but we don't know which one it is, and then we try to clear title out and we name all of the Freedom Mortgage Corporations that exist, it's just a mess, and it's a mess that could be solved quite simply by requiring the plaintiffs to identify in what state they are incorporated. Now, that became very important recently. I've posted 2 appeal issues recently regarding American Home Mortgage Servicing and made the point very clearly that because there are in fact 2, American Home, a Maryland corporation, and American Home, a Delaware corporation, 2 separate and distinct legal entities that are different legal entities as a result of a bankruptcy proceeding, and that has all different implications, both at the trial level and then, as we see in the most recent motion to dismiss I filed, at the appellate level. We need to keep this in mind, particularly when you're dealing with American Home Mortgage Servicing in the trial court context. They like to march into court with the business records of American Home Mortgage Servicing, and they're not acknowledging to the court or disclosing to the court that those business records are actually two separate corporations. The Maryland corporation that existed prior to the bankruptcy, and then the brand new Delaware corporation that was formed and incorporated after the bankruptcy. So you need to keep that in mind, those basics of corporations and entity status in all litigation, whether we're dealing with insurance litigation or shareholder derivative litigation, or especially now in foreclosure litigation. Now, let's talk about why these documents that are sitting right behind me are so important. You see, for years I've been litigating in a case and pursuing discovery, and particularly looking at the discovery related to the trust that is named in the case. We'll call it the XYZ 2006 trust. So it would be Deutsche Bank as trustee for the XYZ 2006 trust. And I've been asking, I want to know the documents that authorize this trust to bring this lawsuit against my plaintiff, let's call him Matt Weidner. So I've asked the court, Your Honor, the Deutsche Bank 2006 as trustee for the blank, blank, blank trust is suing Matt Weidner. I want to see the trust agreements. I want to see that this trust actually has capacity and authority over the note and mortgage that it is suing under, and that it actually has authority to be bringing this suit against my defendant, Matt Weidner. And for years now, I've been getting rejected on that, or there have been being games played regarding whether or not I'm entitled to those trust documents. Now, I want attorneys especially to think about this argument in the context of all civil litigation. Let's say that we were in estate litigation, and I was being sued by John Smith, the personal representative of the estate of Mary Smith. When someone dies, a personal representative is appointed, and that personal representative stands in the shoes of the dead person. They're called the personal representative of the estate. So, again, Mary dies, and her estate sues Matt Weidner. The lawsuit is brought in the name of John Smith, who, pursuant to Mary's will, is appointed the personal representative. He goes into court with the will. The will gives him his letters of administration, and John Smith is formally appointed the personal representative of the estate of Mary Smith, and then they go and sue Matt Weidner for the wrongful death that he engaged in and that resulted in the death of Mary Smith. Well, if I were sued by John Smith, and I had questions regarding whether or not John Smith was in fact Mary Smith's personal representative, because I had information leading me to believe that Mary did not in fact appoint John Smith, but she appointed her brother Bill Smith. So my position in the litigation is, Your Honor, I'm being sued by John Smith, the personal representative of Mary Smith's estate, and I don't think John Smith is the personal representative. I think her brother Bob Smith is her representative. Well, there is no question at all but that in response to that motion, the court would say, whichever one of you, Bob or Mary, because it's been challenged now, you have to provide some proof that one or the other of you is the true and lawful personal representative of that estate. And so John Smith would come into court and say, here's my letters of administration. This makes me clearly the personal representative of the estate of Mary Smith. That is showing up capacity and authority to pursue the cause of action on behalf of the estate. It would happen in any number of different contexts. In trust litigation, if John Smith comes in as the trustee for the XYZ 2006 trust, or more particularly, if John Smith comes in as the trustee for the Matt Weidner trust, and my heirs come in and say, no, Matt didn't appoint John as the trustee, he appointed Sue, then there's no question at all but that the court would say, John, if you assert to be the trustee, and now we've got the beneficiary saying, no, you're not really the trustee, then you need to come to court with some proof that you, in fact, are the trustee. Taking it even further, let's say that we were involved in some sort of insurance-related litigation, and so you've got an insurance company that purports to represent the interest of someone injured in an accident or whatever, and they're purporting to act under some kind of insurance contract. And yet the folks that were injured in there are asserting that, no, that insurance contract doesn't exist and they don't represent us or whatever else. Again, there's just no question but that the court would say, when it is challenged whether or not you, the agent that's coming into court and purporting to act on behalf of the principal, we call the principal in the foreclosure litigation the wizard behind the curtain. There's absolutely no question that in all civil litigation, if any litigant ever said to the court, I want some proof that this agent that is in court purporting to act on behalf of the hidden principal, in fact, has the authority of that principal to act. There's just no question but that in all civil litigation, the court would absolutely always require that to be shown. And so I asked the simple question, how is it that in the context of foreclosure litigation, we have these agents acting all across the country purporting to act on behalf of principals, but they are not being required, heck, and most times they're not even being requested to show that they have the capacity and the authority to act on behalf of the undisclosed principals. I want to know why it is the fact that we're letting this get away with all across the state, frankly, all across the country. The first fault is on the part of every single defendant in litigation, every attorney, every pro se, everybody that's out there. In every single case, the question should be asked, on whose behalf are you acting? That then brings up a much bigger topic about this whole wizard behind the curtain thing. We all need to understand that the real party in interest in the great majority of foreclosure cases, maybe not great majority, but maybe more than 60%, the real party in interest in a big percentage of foreclosure cases is in fact the federal government through its entities, its Frankenstein entities. I'm talking specifically about the government-sponsored entities. You'll hear them called GSEs, Fannie, Freddie, VA, USDA. Understand that the true owners in many of these foreclosure cases are in fact the wizard behind the curtain, the federal government. Now, we could split hairs over whether or not Fannie or Freddie are in fact government entities, and that's the subject of litigation all across this country. In fact, Fannie and Freddie chooses to be a government entity with all the benefits attenuated to being a government entity when it suits them, specifically in the context of these tax cases that are now bubbling up all across the country. So when being a government entity suits them, Fannie or Freddie and these entities wear the robe of a government entity. However, when it does not suit them, then they take off that robe and they assert that we are a private corporation and have all the benefits and protections of a private corporation. But what we as litigants and frankly as all Americans need to understand is that these government-sponsored entities, these Frankenstein combinations of corporations and government entities, should be treated as if they are in fact corporations and litigated against as such. Here's where this is so important. The wizard behind the curtain in a great deal of these foreclosure cases is in fact the federal government. Fannie Mae, as the real party in interest, as the owner of these loans, as the person that's driving the action and it's pulling the strings on these things, must be brought into the litigation. So we have to rip back that curtain and get to that wizard behind that curtain and understand the extraordinary impact of having Fannie at the table and taking responsibility for what they are doing. Now, I'm not often a big defender of the banks, but there is a reality that is coming to the surface now that we all need to keep in mind. And that is, it's very easy for us to demonize the banks and the institutions and the servicers. And Lord knows I've been more guilty of that than probably anybody. It's very easy to pick at Bank of America and Wells Fargo and Citi and Chase and all these other things. But we need to evolve our understanding to recognize the fact that the servicers, and let's talk about what that means exactly, because the truth has been right there in front of us all along. When these banks and institutions are suing us as the plaintiff, as the servicer, they are in fact just acting as an agent for an undisclosed principal who's hiding behind the scenes. And when that undisclosed principal is Fannie or Freddie, they are the ones that are directing all the action. And I believe at the end of the day, the servicers have little or no discretion over much of what they're doing. And this drives so much of the frustration in litigation, and it's something that we all need to be acutely focused on. This is particularly apparent in dealing in situations like loan modification or short sale or any other kind of workout discussions, because you know, I always talk about the fact that I'm not a free house attorney. I have a carrot and stick approach. The carrot is we got to work something out between my reasonable defendant homeowners that are sitting here in my office and the bank that's on the other side of the table. I view my job as an attorney, as an advocate, and as a responsibility to the entire court system to try and work this out. So as I have homeowners sitting here, I'm not a guy that thinks a homeowner is going to camp out for 2 years not paying anything. I've said this from the beginning, and I'm even more committed to this now than ever, is that it's good for that homeowner, it's good for the court system, it's good for this country as a whole to have that homeowner in a home, making a payment, paying taxes, paying insurance, taking care of the property, having some buy-in and investment into this house that we are litigating. I don't like the fact that homeowners sit there forever not paying anything because we're not fully engaged and invested into this process. However, even as I speak very reasonably about that, about my responsibilities to the court system and to the larger society as a whole, we run into a brick wall against the plaintiffs in these cases, where the banks will not accept payments from homeowners, will not work with them on insurance and taxes and all these other sorts of things. It's just all or nothing. They either conclude the foreclosure and get a foreclosure judgment, or nothing at all happens. They will not take partial payments from homeowners. They will not work out reasonable modifications. They will not accept short sales. They won't do anything that might conclude the litigation short of going to a foreclosure judgment. And this is particularly apparent in those cases where the foreclosure case is so messed up that they can't possibly get a foreclosure judgment. So for years we've been wondering just what in the heck is going on here. You know, an example of a case that's so messed up they can't get judgment would be, let's say they've got an obviously flawed or fraudulent endorsement, or they've got other inaccuracies, we'll call them, or lies within the pleadings, which make it difficult or even impossible for them to get a foreclosure judgment. In that case, I'd approach the other attorney and say, look, your case is so screwed up, you're not getting this judgment. Let's work something out here. Give them a modification. I don't even care about a principal reduction. All this client wants is a monthly payment that they can make going forward. And the other attorney, recognizing and acknowledging the problems that they have with the case, will refuse to accept anything. And I've had this happen in the context of a court battle. You know, you're sitting there with a judge going, Your Honor, look at this endorsement on here. It's obviously flawed. It's fraudulent. And the other side will kind of shrug their shoulders and go, yeah, Your Honor, he's right. And so the question is, why can't we just work this out? And again, rather than just working it out, the plaintiff goes, geez, we can't do anything. Well, I've come to recognize recently that it's not my colleagues on the other side, the plaintiffs, that can't work something out. It's not even the plaintiff, Bank of America, let's call them, that can't work this out. Because clearly the bank, this corporation, would want to do what's the best interest. But the fact of the matter is the reason why in those desperate situations where the plaintiff is backed into the corner and they have no hope and they can't go forward with a judgment, the reason why they won't settle that case is the wizard behind the curtain, Fannie, Freddie, and the other entities that are driving this train won't let them do it. This has other consequences as well as we spin out to the insanity of the foreclosure sale. You know, we talk about this foreclosure crisis, and one thing that I've talked about for months that nobody seems to care about is the fact that despite the fact that we're years deep into this crisis, in my county, Pinellas County, I think about 30,000 foreclosure cases pending with new ones being filed every day. Despite the fact, and after years of these cases pending, in 2011 there were only 3,000 foreclosure auctions in the entire county. 3,000. And of those 3,000 auctions, only 536 made it to third-party purchasers. That's an incredible number. 3,000 auctions, 536 go out there into the private marketplace. What's happening with the others? Roughly 90% of those? They're going back to the servicers. They're going back to Chase. They're going back to Bank of America, Wells, and Citi. Why is this? Well, again, this gets back to the wizard behind the curtain issue, I believe. The banks and institutions are bidding these judgments up so that they ensure that they take the property back. The reason why they're not going to third-party purchasers is not because there's not an active private marketplace out there. I watch all of the foreclosure auctions, and I see the properties being bid up at these auctions to numbers that are greater than the actual market value of the property. Part of that is what I call stupid money. Most of these auctions in the state of Florida are now online, and so rather than having just folks within Pinellas County bidding on these properties locally, folks that would go out and actually drive and see the property and recognize that that junky wood frame house is only worth, $20,000, you've got people from all around the world literally bidding on these properties. And so that property that any reasonable person here in Pinellas County would know is only worth $20,000, you have somebody over in China or someone up in New York that's bidding $50,000, $60,000, $70,000 for these properties. You see it happening all the time. So there is an active marketplace out there in these auctions where people would be snapping these properties up for more than they're going to net when they take the property back, but the banks are not letting them do that. The auctions are almost always going back to the plaintiffs, back to Bank of America, back to JP Morgan, back to Wells Fargo for high amounts, in some cases for just $100, despite the fact that there are people out there legitimately bidding on those and bidding for prices that would net the servicer more than they're going to get once they take it back and if they were to sell it. Now, the reason for this is the money on the back end. That's one of the reasons. There are other reasons involving title and other problems, but the fact of the matter is that in the vast majority of cases, these properties are going back to the banks and institutions, and then something's happening between the banks and the government-sponsored entities, Fannie, Freddie, and the other entities that are involved in these foreclosure litigation cases. Now, the reason why that's happening, and the reason why that's important to understand, is if we appreciate the fact that the end result of every foreclosure case should be an auction where the property goes into the marketplace and some third party, a good party, can get into that property. We all need to be desperately concerned and understand why that's not being allowed to happen. Those are important economic circumstances. If we're filing a foreclosure case in 2008 or 2009 and it's taking 3 years before it makes it to the auction block, and then at the end of that auction block, it's not even going to a third party. It's going right back to the plaintiff. Consider this. Why are we allowing this to happen if, when that case was filed in 2008, the homeowner defaulted, nobody filed anything? Chase filed a case in 2008, and no homeowner did anything at all, or the homeowner tried to do a short sale, or the homeowner tried to do a deed in lieu even. Why wouldn't the bank take that property back rather than waiting 3 years for a foreclosure auction, and then they just ultimately take the property back anyway? We all need to understand why that's occurring and why it's occurring in such a widespread and systematic basis. In fact, like 90% of the times. It's an important consequence we all need to understand. Now, right back here to these documents here behind me. You'll see this. I want you to pay attention to look at just how fancy that is. See that nice blue ribbon on there and the gold seal on there? And look, the United States of America. And that comes directly from the Securities and Exchange Commission. Well, the reason why this is so important is for years, again, I've been asking for these documents in the context of litigation. Formally through discovery, as you attorneys know, when you ask in discovery, you're supposed to get all these documents, and I've been getting the runaround for years. And so one of the things that we did was a client, frankly, went and made a public information request directly to the Securities and Exchange Commission. And what we got as a result of that is what you see stacked right here. About a foot worth of documents. God knows how many pages are in here. And again, every one of them, I love it when they come this way. Look at it. You get that beautiful gold seal on there, and then the blue little ribbon. It's got the seal of the United States of America, and it's all very formal, and all those lines and everything there. The reason why this is so significant, again, in the context of litigation, I've been told I can't have these, or you're not entitled to those. But the fact of the matter is that they exist. Thinking about trust in particular, which is kind of where we started off, this is what most of the trust in the documentation for a mortgage-backed security trust should look like. In here, we've got the pooling and servicing agreement, we've got the 8K schedule, we've got everything that should have been produced as part of a normal mortgage-backed security REMIC pool. And yet, despite my hundreds of cases over years, I've never seen all of the documents produced this way. Well, here we have it all right here. Here's why it's important. Here's why the PSAs are still so important. In the underlying foreclosure case, they're making representations about who owns, who holds, who has rights, where the loan went, and all these other things. And I've been told from the beginning that you're not entitled to it, you can't get it. Well, or in other factual statements in the context of that litigation. Well, what's contained within here is evidence that those facts were not in fact true, that there are misrepresentations in the underlying litigation that are contradicted by the more factual information that's included right here. Other things to keep in mind. In the context of our underlying state's foreclosure litigation, we're told all sorts of things that we're not entitled to account histories. We're not entitled to life of loan, history of a loan. You need to keep in mind that there are detailed and sophisticated computer programs that the banking industry has produced and utilizes on every single loan. And if not, they've got more problems. But there are a variety of computer systems that contain all sorts of detailed information. In most cases, every single contact that they've had with the borrower from the life of the loan, every phone call, every letter, every email, they're boarded onto a system that tracks that. That may be one separate and distinct system. Another separate and distinct system is a document tracking system, which would show where that original loan and the note went from the time of origination to foreclosure or even into bankruptcy. You know, for years we've seen these lost note counts, and those were just gross misrepresentations in most cases, because in fact the industry, the lending industry, has detailed and sophisticated computer programs that show exactly where that original note went from origination to a vault. If it ever went out of the vault, there were tracking numbers associated with it. There were Bailey letters associated with it. Sometimes there's insurance policies associated with it. So the notes are treated just like evidence in a criminal case, where each step, each chain in the custody was established and signed off on pursuant to very specific procedures. So that's a second computer system. A third one might be things related to property preservation and what they were doing when they went out there and made these false inspections. And there are other document creation systems that are all involved. So the thing to keep in mind is this. When you go into discovery of the foreclosure litigation, particularly the state court and otherwise, we're told these things don't exist, you're not entitled to them. If you don't press hard enough, you're not going to get them. But the fact of the matter is that the wizard behind the curtain has all of this information. In very sophisticated ways, the wizard has this information. So your job as attorneys and advocates is to make sure that in discovery, you're digging in there and getting all this information. And this example right behind you of these, foot stack worth of documents right here will be very valuable in the information you can collect. Here's another fascinating thing. This whole stack of documents right here in the big box that it came in cost a total of $12. So when you make those requests, that right there costs $12. Think about that when you compare it to the cost of actually litigating and trying to get it some other way.